The Minister of Basic Education, Siviwe Gwarube, has officially gazetted the first two sets of regulations under the Basic Education Laws Amendment Act 2024 for public comment. This marks a significant milestone in the responsible and inclusive implementation of the BELA Act. The Act is aimed at strengthening the governance, equity and quality of education for the country's 13.5 million learners. The gazetted regulations relate to key provisions of the South African Schools Act regarding school capacity and school admissions. These are designed to ensure that the amendments introduced by the BELA Act are implemented. The regulations seek to uphold learners' rights, enhance school functionality, and maintain the careful balance of power and functions between school governing bodies and government in the proper management and governance of schools. Further regulations will be released for public comment as soon as they are finalized, legally vetted and approved. We're now joined by the Minister of Basic Education, Minister Siviwe Gwarube, to further unpack this. Minister, good evening. Thank you so much for your time. Really do appreciate it. I think I'll jump straight into perhaps what is the controversial part of the regulations, and that is the admissions of learners to public schools regulations. Extensively, these have been ventilated in public over the last couple of years. That culminated into the Act, and now the regulations therefore have been, at least draft regulations have therefore been published. Perhaps take us to what is at the heart of these regulations in terms of what it wants to and aims to achieve as far as inclusivity is concerned.
Yeah. Good evening, Oliver, and good evening to your viewers. Firstly, we are really glad that we were able to, within a space of a couple of months, be able to develop these regulations, because you'll recall that the Act was commenced with in December 2024, and we had to really move with speed, particularly because we had the legal requirement of ensuring that grade R was already made compulsory from the beginning of this academic year. With regards to the admission policies, what it really seeks to do, and the regulations, what they seek to do, they seek to give clarity, legal clarity and guidance within provinces. You will understand that admission policies, for instance, are determined by the SGBs. But what the BELA Act seeks to do, which has emanated from extensive case law, is that it seeks to regulate the relationship between provinces and SGBs. Because there have been instances in the past, for instance, where a province or a school has been taken to court with regards to these admission policies of their various schools. So what it seeks to do is that it clarifies very much in clear detail in terms of what is the relationship between the SGB and their ability to determine the admission policy, but also what then happens when there's a dispute. And this is where I think the regulations will come in handy, because it now stipulates that the HOD does become the appeal authority at the initial stage, sort of the arbiter between, I suppose, a parent and the SGB of a school. And so what then the HOD would do, they would, in consultation with the SGB, determine what the issue is. And then, of course, the MEC will become the final arbiter or appeal authority that then the parent can essentially appeal to. So this is important because in the past, there hasn't been legal clarity on how do we regulate that relationship, maintaining the independence of the SGB, but while also saying that government has a role to play in saying, look, the admission policies can't be discriminatory in nature, for instance. They can't essentially be arbitrary in the way in which that they are applied. And so I think these regulations will go a long way in doing that. And I'm really hoping that South Africans, groupings can really participate in the public process.
I don't think it will be long before we see litigation specifically around the relationship between HODs and SGBs, particularly because the language, it introduces new language to define that relationship. In one instance, it talks about the HOD being having the power to override the language policy of a school in either by telling the school to review its policy or by completely overriding it when it's not in tandem, or at least if it's not consistent with the provincial transformation targets and or provincial objectives. It, however, says that HODs must consult with SGBs. What does that word mean legally?
And this is very important. And this is part of the reason, Oliver, while this process has been really one that we've had to be thorough in. Because one, in drafting the regulations, yes, the minister is empowered to draft regulations, but in drafting these regulations, what we did with the process that we undertook is one, we've put together task teams that involve education specialists, that involve stakeholders across the sector to say, be part of the task team in drafting the wording of these very regulations. Over and above that, we've taken these regulations through to the Office of the Chief State Law Advisor so that they can ascertain whether or not the regulations are not a departure from the spirit and the letter of the original legislation, which is what they were looking for. And so when we got the green light, we were able then to publish. So I'm quite confident that in the way in which it is worded, that it will cover what it is that provinces need clarity on. When it talks about consultation, well, the reality is that, Oliver, that SGBs are the very first point of contact, the very first sort of governance unit at a school. And so they determine, for instance, the code of conduct of a school. They determine the admission policy, the language policy, language, learner pregnancy policies. All of these things have to be subject to the South African Schools Act and, of course, the Constitution. And so the consultation element of it is to say we're not building an education system that must be litigious in nature. We're saying that the HOD must consult and say, well, what exactly is the issue and how is this admission policy inhibiting the admission of specific learners? However, they do then, as you will read the regulations, once these consultations have taken place, which is important, at least in accordance to PAJA, that once these consultations have taken place, then the HOD and the MEC can't have the final say, because ultimately they would have consulted and engaged with the SGBs.
Let's go to the spirit of it, particularly around admission, and the controversy around it is language. It says language policy can no longer be used directly or indirectly as a gatekeeping tool to exclude learners from other language groups, and therefore language can no longer be an exclusionary measure, or at least arbitrarily so. Let's then talk about how SGBs are being empowered to be able to make the right language policy adjudication, particularly because the language policy of the school must reflect the demographic and geographical makeup of the area that the school finds itself in, coupled with the fact that it's further complicated by the reconfiguration of what is considered the feeder zones, which might be a geographical input into a particular school that falls outside of the immediate geographical zone of a school. I would imagine it would be an incredibly laborious exercise for an SGB to determine how many people speak what language here, and how do we make the right decision around that. In what ways are SGBs going to be empowered to be able to make the right decision so that not every case ends up at the door of the MEC and ultimately the door of the minister?
Yeah, and absolutely. And this is part of the reason why we have undertaken to not only train the provinces and provincial officials, but also to take this very much down to the school level, to the SGB level, because I agree with you. I think that, it's been deeply unfortunate that there's been a lot of politicization around this piece of legislation, to the point where it has really, I think, soiled in some ways the very collaborative nature that provinces can have with schools and SGBs. But in my interaction with schools, and definitely at least principals and the like, people are saying, look, we want to be able to craft admission policies that are in line with the legislation. And so that training has already started to take place, Oliver, across the country in various provinces, from a provincial level down to a circuit level, even from a district to a circuit level. So I'm confident that both the regulations will serve as a very useful tool for school SGBs and also school principals, so that they can understand what it is that the law seeks to do.
Yeah, of course, this is still out for consultation, so these aren't the final regulations, and they might look different towards the end of the process. But I have to ask you about this, and this is about grade R admission being compulsory. What is the expectation on schools to now attach to its current register grade R classes, and how many are they supposed to be doing so? But more importantly, 346.5 billion is the projected basic education budget, not enough to cover what is already needed in the system. And now you're adding, and of course, this has been a controversy of the regulations as well. Now it's being added grade R learners to the system at a compulsory level, which means that schools can't turn grade R learners away. How much more money is needed for that?
So our estimation, Oliver, is that there's about 17 billion rand that we need to invest within provinces to be able to absorb the grade R learners. Of course, in the last 5-10 years, a lot of schools have included grade R, but a lot of children, we are anticipating about 70% of grade Rs are already included in the schooling system, but there is still children who don't have access to grade R. And also, complicated by that is the fact that we still need to also take into consideration the grade R that is offered at ECD centers and how that is incorporated in formal schooling. And so, yes, with the stroke of a pen, that became compulsory. And so that is going to be a financial pressure on the system. But in my view, this will go a long way, Oliver, in ensuring that actually we start to improve the foundations of learning. The fact that we have a massive interest and emphasis and investment in ECD will allow us essentially to have a grade R that is attached to schools. And of course, it does require investment. And this is the conversation I've been having with the finance minister since last year to say we do need additional funding, because at the moment, provinces are expected to absorb that additional requirement, and we have made already a submission to Treasury around the fact that we do need additional funding for this legal requirement. Because remember, education is not progressively realizable. In the Constitution, it makes it quite clear. And so if a parent from Umqanduli says, I want to take my child to grade R, but the nearest school that offers grade R is 50, 100 kilometers away, we need to make sure as the education system that there is access to grade R, because it is now legally compulsory to do so. So there is a long road ahead, but we're not starting from scratch. And I'm hoping that the numbers, that the intake of grade R learners will be a lot more than we saw in 2026, in 2025, as we go into the academic year in 2026.
Yeah. Happy Women's Day to you, Minister, and the women of basic education across the country. Really appreciate your time this evening.
Thank you very much.
And that is the Minister of Basic Education, Minister Siviwe Gwarube, and of course talking to us about the BELA regulations as well as what to expect around the admission of grade R.